Thank you for joining us today. Today we will be providing a presentation on renter protections in the City of Los Angeles. This presentation is being provided by the Los Angeles Housing Department. The information in this presentation is intended only to apply to residential units located in the City of Los Angeles and not to commercial units. It is also information that is not intended for properties outside of the City of Los Angeles. The general areas we will cover today include the difference between the city versus the county areas, a description of what the city's rent stabilization ordinance is, commonly referred to as the RSO, renter protections update as of February 2023 moving forward, the City of Los Angeles Just Cause Ordinance effective January 27, 2023, some other new laws on tenant protections, and finally, how to contact the Los Angeles Housing Department. It is very important for landlords and tenants to be able to distinguish whether their property is located in the City of Los Angeles or in the unincorporated area of Los Angeles County. Unincorporated areas in the LA County are not part of the City of LA. They are not part of any city. They are part of the Los Angeles County. The easiest way to determine if your property is in the City of Los Angeles is to see who you pay your water and power bill for the rental property. If the rental property in question is paid to the Los Angeles Department of Water and Power, LADWP, then the property is located inside the City of Los Angeles. Whereas if you pay your water or power for the rental unit to a different company, such as Edison or a different water or power company, then you are not located in the City of Los Angeles. Likewise, if the Los Angeles Police Department provides services to your area, then you're in the City of LA. If police services are provided to you by the Sheriff's Department or by some other police department, you're not in the City of Los Angeles. You could also look up the property address of the rental unit at neighborhoodinfo.lacity.org. When you enter the rental unit address in the search bar, you will get a result providing you information about the rental unit, including the council district it's in and some other details of the area for the rental unit. However, if when you enter the address, you get a search result that says nothing found, it means the property is not located in the City of Los Angeles. If your rental unit is not located in the City of LA, then please contact the Los Angeles County. They can be contacted via phone at area code 833-223-7368. Or you could go to their website at rent.lacounty.gov. Once you have determined if the rental unit is located in the City of Los Angeles, the next important item of information to know about the rental unit is whether or not it is subject to the City of LA's Rent Stabilization Ordinance, commonly referred to as the RSO or the rent control laws. Under the City of Los Angeles law, a rental unit is subject to the RSO if it was built prior to October 1st of 1978. In some circumstances, the units will also be subject to the RSO if they were built after July 16, 2007, under the Ellis replacement provisions. The RSO mainly does a couple of things for rental units. First, it stabilizes rents and regulates the annual allowable rent increase percentage that a landlord may apply to a rental unit. Second, it requires a just cause reason for eviction to terminate a tenancy, and those include at fault and not at fault reasons. And third, for no fault reasons, it requires that a landlord pay the tenant relocation assistance. If you would like to confirm if the rental unit is subject to the RSO, you may go online to the website at themas.lacity.org, and you can enter the property address in the search field. If the search results give you a yes RSO, then the property is subject to the RSO. If it says no, then it is not subject to the RSO. An example of the search results are seen on your screen on the right-hand side. As you can tell, under the accordion titled Housing, there's a label named Rent Stabilization Ordinance RSO, and next to it is a no, or there will be a yes if it is RSO. Lastly, you could also send a text message and obtain the RSO status. You would need to send the letters RSO to the number 855-880-7368, and the text message will prompt you to enter your property address and will let you know if the property address you entered is or is not subject to the City of LA Rent Stabilization Ordinance. The City of Los Angeles Declaration of Local Emergency, which was effective starting March 4th of 2020, ended on February 1st of 2023. However, there are still some remaining protections for tenants in the City of Los Angeles. These protections apply to all residential units in the City of LA, regardless of whether or not it is subject to the RSO. For non-payment of rent, the protections that still apply are as follows. Beginning February 1st of 2023, tenants do have to pay their full current monthly rent in order to avoid eviction for non-payment of rent. So for example, rent that became due on February 1st of 2023 must be paid in February. Rent that became due in March of 2023 must be paid in March, and so on. However, low-income tenants who fell below the 80% area median income and who were impacted by COVID-19 continue to have protections through the month of February and March of 2023 under the LA County provisions. That LA County provision for February and March of 2023 also applied to the residential units in the City of LA. The county rule was that tenants were required to have notified the landlord within 7 days of the rent due date that they were both low income and COVID-19 impacted and therefore were unable to pay their rent for February and March of 2023. Tenants who were eligible for this county provision will have until March 31st of 2024 to pay the unpaid rent for the months of February and March of 2023. As an example of the income levels that were required for the county protection for these 2 months, you see on your screen a chart of the 2022 HUD low income limits for the county. Depending on the number of people in your household, that will determine the total amount of household income that would make a household eligible for the county protection for February and March of 2023 only. So, for example, a household of two people, the total income would be $76,250. If a household makes below that, they would be considered low income for purposes of the county protection. Additionally, there are state law protections for all tenants in the city of LA and statewide. That protection indicated that if a tenant gave to the owner the COVID-19 related declaration of financial distress by a 15-day deadline for rent owed between the months of March 1st of 2020 through August 31st of 2020, then the tenant cannot be evicted for rent that is still owed for those months. Additionally, the state law said if the tenant also gave a copy of the declaration to the landlord and paid 25% of the rent that was owed for the months between September 1st, 2020 to September 30th, 2021, then the tenant may never be evicted for non-payment of rent for those months. Although a tenant cannot be evicted for non-payment of rent for these months if the tenant complied with the state law, the tenant still does have a financial obligation to eventually pay the rental debt. However, if they comply with state law, that obligation cannot be complied with through means of an eviction. The owner cannot evict the tenant for that. The landlord would have the option of taking a tenant into small claims if there was still a rent balance owed for those months. Under the city rules, there is an additional protection for tenants who have not paid their full rent for the months of starting March 1st of 2020 through January 31st of 2023. But there are very specific guidelines that regulate this protection. For the months of March 1st of 2020 through September 30th of 2021, if the tenants still owe rent for those months, and the reason they still owe the rent is because they were financially impacted by COVID-19, the tenants have until August 1st of 2023 to pay the rent owed for these months. There's a different deadline for rent that's owed from October 1st, 2021 through January 31st of 2023, and there's a line all the way at the bottom of the screen. But what it says is that rent that is owed from October 1st of 2021 through January 31st of 2023, tenants must pay rent that is owed for those months by February 1st of 2024, next year, which means a landlord may not evict a tenant for non-payment of rent where the tenant was impacted by COVID-19 during these months until the repayment period deadline. And once again, there are two repayment period deadlines under the city rules. One is August 1st of 2023, only for the months between March of 2020 through September 2021. And the second repayment deadline for tenants is February 1st of 2024, next year, for the months between October 1st, 2021 through January 31st, 2023. Some additional protections that apply in the city of Los Angeles to all residential units include protections from evictions for unauthorized pets and unauthorized occupants when it is related to COVID-19. Until January 31st of 2024, next year, landlords cannot evict a residential tenant based on the presence of an unauthorized occupant or unauthorized pet that is necessitated by COVID-19. Prior to evicting a residential tenant based on the unauthorized occupants or pets, landlords will be required to first serve the tenants a 30-day notice to cure. So a 30-day notice to correct the alleged violation of the unauthorized pet or unauthorized occupant. This 30-day notice cannot be issued until next year, January 31st of 2024, because tenants cannot be evicted until after January 31st of 2024 for this reason. For no-fault eviction reasons, such as when an owner wants to occupy their unit, or when an owner has to comply with a governmental agency order, or they seek to demolish the unit, these no-fault evictions are being allowed to be filed with the housing department starting February 1st of 2023. Landlords who seek to evict the tenants for a no-fault reason are required to file a document titled Declaration of Intent to Evict before they can serve the tenant a notice to terminate tenancy. Additionally, tenants who had already received a no-fault eviction notice prior to March 4th of 2020 must receive an additional 60-day notice from the landlord that cannot be served earlier than February 1st of 2023. Ellis Act evictions were not enforceable in court until April 1st of 2023. A specific protection only for RSO units in the city of Los Angeles is that the annual rent increases for the RSO units cannot take place until February 1st of 2024, next year. That is why it's very important to also know if the rental unit is subject to the RSO, because that will tell a landlord and a tenant whether or not a rent increase is currently allowed. And if it is subject to the RSO, the rent increases are not allowed until February 1st of next year. Landlords cannot collect interest or late fees on unpaid rent for tenants that were financially impacted by COVID-19 for the months of March 1st of 2020 through January 31st of 2023. So if the tenants did not pay on time during those months, or even if they still owe rent for those months, a landlord can never collect late fees for those months if the tenant was financially impacted by COVID-19. Additionally, under the county rules, for the months of February and March of 2023, if the tenant qualified for the additional county protection that we previously discussed, then the landlord can also not collect late fees or retroactive late fees for February and March of 2023. On the topic of rent increases, one thing that's important to remember is even if your unit is not subject to the city's RSO law, there is a state law currently in place under Assembly Bill or AB 1482. Under the state law, that became effective January 1st of 2020, it applies to most properties that were built between 1979 through 2007. A landlord cannot increase the rent more than 10%. Currently, between August 1st of 2022 through August 31st of 2023, the maximum allowable percentage increase is 10% for units that are not subject to the RSO. So that's very important to distinguish. If your unit is subject to the RSO, no rent increase, 0. If your unit is not subject to the RSO, then a landlord may apply a 10% increase on the unit. Please note that percentage increase is subject to change every year, depending on the consumer price index or the cost of living for the county. Currently, in the city of LA and the county of LA, it's 10%. One very important thing to make note of for units that are not subject to the RSO is that effective January 27th, 2023, the city of LA implemented a new law. This new law is referred to as the Just Cause Ordinance and applies to all residential units in the city of Los Angeles that are not subject to the RSO. This applies after the expiration of the initial lease or after 6 months of continuous occupancy by the tenant, whichever date comes first. The Just Cause Ordinance is very similar to the RSO rules in terms of the eviction protections it provides to tenants. The Just Cause Ordinance provides legal reasons for eviction that are at fault. For example, non-payment of rent within the limitations of the COVID protections, of course, violation of a lease, nuisance, using the property for an illegal purpose, failure to renew a lease with similar terms, denial of access into the unit by the tenant, tenants that are not approved by the landlord, and this typically involves when the original tenant has moved out and whoever's left is someone the owner has never rented to. That's really what this refers to, as a subtenant not approved. It does not refer to unauthorized occupants that continue to live with the original tenant. And finally, a legal reason to evict the tenants where the tenant's at fault is failure of the tenant to comply with an approved tenant habitability plan. And that really is a legal reason for eviction that only applies to RSO units. It does not apply to just cause units. So number 8 is only RSO, not just cause. The Just Cause Ordinance also contains no fault tenant eviction reasons, such as owner, family, or resident manager occupancy, demolition, withdrawal, or substantial remodel of the unit, compliance with a government order, such as when building and safety issues, a substandard order to a garage that's being occupied as an apartment without permits. Convert to affordable is a legal reason. Conversion of a residential hotel to some other use is also legal. And when HUD owns the property and they are going to sell it. These no-fault tenant eviction reasons all require that the owner file a declaration of intent to evict with LAHD and pay the tenant relocation assistance. The relocation assistance amounts under the Just Cause Ordinance are displayed on your screen, and they range in amount depending on the specifics of the unit. For a qualified tenant who is a tenant or a household where occupant is disabled, elderly, 62 years of age, or a household with a minor dependent child, the relocation amounts vary from $19,400 to $22,950. And for eligible tenants, they vary from $9,200 to $12,050. Under very specific reasons, a landlord may qualify for a reduced relocation amount. These properties are commonly referred to as the mom and pop landlords, who could be eligible for a reduced relocation amount only for evictions that are based on owner, family, or resident manager occupancy. Lastly, under just cause, single-family dwellings owned by natural persons are eligible to pay 1 month's equivalent of rent for relocation to a tenant. So this is very specific, only for just cause ordinance, only where you have 1 unit on your parcel, and when the property is owned by a natural person, meaning if the property is owned by a corporation, they don't qualify for the 1 month relocation. For no-fault eviction reasons under the Just Cause Ordinance, landlords can also resume these evictions on February 1st of 2023 and have to file a declaration of intent with the housing department. They must pay the relocation assistance to the tenants. And one important note on relocation payment, which applies to both RSO and Just Cause units. When a landlord is evicting a tenant for no fault and has to pay relocation assistance, there is a new law that applies that says a landlord can deduct the tenant's unpaid rental debt from the relocation assistance payment. And that's for both RSO and Just Cause Ordinance units. A new requirement for landlords in the city of Los Angeles is that they have to file a copy of any eviction notice they serve on tenants in the city of Los Angeles. They have to file it with the housing department no later than 3 business days after service on the tenants. To file a copy of this notice, we recommend that you go online. We have a system online that will allow a landlord to enter some basic information about the unit and the notice and to upload a copy of the notice. A landlord could go to housing.lacity.org/eviction-notices to access the online portal to upload the eviction notice. Likewise, all no-fault eviction notices must be filed with LAHD no later than 3 days after the notice is served on tenants. Landlords who don't have access to a computer and are not able to upload the notices online can mail in their notices, but they have to complete a cover sheet that they will also find on the website link indicated on your screen, housing.lacity.org/eviction-notices. That will give you the link to the cover sheet to mail in the copy of the notice, and it will also give the link to the online portal. Another new requirement for landlords is that they have to give tenants a copy of a protections notice. It's a 2-page document that you see on your screen the image for, and it includes all of the rules under the RSO and under the Just Cause Ordinance, including the COVID rental protections. This notice must be displayed at the property at an accessible common area. For example, a laundry room would be a perfect place to place a copy of this notice. If you don't have a laundry room, then you will have to find another visible place at your property to post this notice. A law that's been in the books since August 6th of 2021 and applies to all residential units in the city of Los Angeles is the Tenant Anti-Harassment Ordinance. This law essentially prohibits a landlord from harassing a tenant from their units. And there's a series of examples, a list of behavior that could be considered harassment and is indicated in the ordinance. For example, if a landlord takes away housing services, refuses to do repairs, enters the apartment without proper written notice, threatens the tenant with physical harm, tries to coerce the tenant to move out with offers of payments, and so on. There's several other items that are listed in the ordinance that could be viewed as harassment against a tenant and are prohibited under the law. If a tenant believes that they are being harassed, they can contact the housing department at area code 866-557-7368 to report the issue. Harassment can be a very challenging issue to prove, so tenants should keep records, should take notes of any events they believe are harassment with details so that they may provide any documentation to the housing department. And of course, if it is an emergency, something that involves physical danger, then parties are advised to call the police department. Another new law in the city of Los Angeles, effective March 27th of 2023, tenants who receive a rent increase of more than 10% within the 12-month period and who cannot afford to pay this rent increase have the option to receive relocation assistance to move out of their unit instead of having to pay the rent increase. The relocation amounts for this reason are different than for no-fault evictions previously discussed. The relocation amounts for the rent increase are based on the total number of bedrooms in the unit. So, for example, in the chart that's displayed on your screen, a one-bedroom apartment has a rental rate of $1,747. So the tenant would be eligible to receive $5,241 plus moving costs of $1,411 for a total of $6,652. The relocation amount increases as the number of bedrooms increase. One exception, though, is when the property is only one unit on the parcel, a single-family dwelling, owned by a natural person, meaning not a corporation. These single-family natural person properties can pay the tenant relocation of no more than 1 month equivalent of their rent. Once again, a landlord can deduct the tenant's unpaid rental debt from the relocation assistance payment. Another new law effective March 27th of 2023 is that landlords may not evict a tenant who falls behind on rent unless the tenant owes an amount higher than the fair market rent. The fair market rent depends on the bedroom size, the number of bedrooms of the rental unit. It's not really the size, but it's the number of bedrooms of the rental unit. For example, if a tenant rents a one-bedroom unit and the rent is $1,747, then the landlord cannot evict that tenant because the total amount of rent owed is less than the fair market rent. Notices to terminate based on non-payment of rent must include in them the total number of bedrooms for the unit to be valid under the city laws. If you have follow-up questions to this presentation, you may contact the Los Angeles Housing Department in different ways. One is to send an email using the housing.lacity relocation.org/ask-housing app. Since that's a long address, you could also just Google LEHC Ask Housing, and it should take you to the link where you can click on it and fill out a form, which essentially sends an email to the housing department with your specific question. You will be asked to provide the property address and your contact information so that the housing department may email you back a reply. You may also contact us via our general hotline at area code 866-557-7368. And tenants may file a complaint online as well, going to housing.lacity.org/file-a-complaint. If you have additional questions, you may also read the material on our website. Our main website, our homepage is housing.lacity.org. And from there, you could actually navigate to various pages and bulletins to acquire additional resources and additional information. And we specifically have a web page for rental protections that you could read and contain more detail on the material that was covered in today's presentation. Once again, our general hotline is area code 866-557-7368. You can RSVP for future workshops by signing up to our newsletter, and you will get an email notification. Or you could also RSVP for the workshops by calling 213-928-9075. That concludes the presentation for today. Thank you for your time.